In the Is It Legal segment tonight, a ton of stories to report. We begin with a very shocking situation out of Texas. 12-year-old girl, sixth grader, runs away, winds up working as a stripper in a Dallas nightclub. But the club is allowed to stay open. With us now, attorney and Fox News analyst Lise Wheel, and attorney and Fox News anchor Megyn Kelly. All right. Girl runs away, partners up with a stripper and a guy, I guess a boyfriend or something. They bring her into the club. She works there.
Yeah.
Gets paid. And now you're telling me that the authorities can't close the club down?
Yeah, that's the deal. Because the city ordinance, which governs these sexually oriented businesses, enumerates the grounds on which one's license can be revoked. Mm-hmm. And having someone underage working in your establishment is not one of the enumerated grounds. So
is this an oversight? Is this an oversight? You think it's just an oversight?
I know it is, because I've talked to lawyers down in Texas who are familiar with the law in other counties, and other counties do have the line in their statute.
If you're underage, because I want everybody.
This county doesn't.
We're not doing this to be prurient, but we want everybody to know that this girl took off all her clothes, 12 years old. Now, we don't know whether the club checked her ID, even asked for an ID.
Well,
we don't know any of that.
They didn't ask for an ID, and the guy actually gave her a false. He said, well, to be of age, you'd have to be born in this year. And so, oh, that's when I was born then, because she couldn't remember her birthday when she first came out. So they clearly knew. And I disagree. I think
Where did you get that last piece of information, Bob?
That was absolutely the information we were going over today.
That's been
absolutely.
Reported.
It's been reported.
They did ask her for the ID, and she said she didn't
have it. And she forgot her birthday.
She said, I don't have it.
So the club management, can imagine,
so to speak,
says, where's your ID? I don't have one. And then she doesn't get her birthday.
What's your birthday?
Right.
Oops, I don't remember my birthday.
And he says, well,
still lets the girl work.
He says, just FYI, you'd have to be born in 1988 to work here legally. And she says, oh, that's when I was born.
That's when I was born.
All right, so let's assume that the club didn't care.
Right.
All right, because I think that could be probably proven in a court of law.
Right.
Didn't care, throws the girl on the stage, 12 years old, gets paid, goes all through this thing, and now the club is still open for business.
It's absolutely crazy. And I think that there's a lot of room in this law. First of all, it's a discretionary thing whether they give a license or not. It's a privilege, not a right to have a license. And also, that's a civil law. I think criminal law trumps, because you've got child endangerment.
What would you charge if you were the DA?
Sexual contact, perhaps, if she's been touched in any way. I mean, you could absolutely charge this.
Look, the DA is sitting there. The DA is listening to this, all right, in Dallas, and says, okay, I'm going to charge with what? Corrupting the morals of a minor?
Child endangerment, absolutely. And as I say, if she's been touched
they could do that.
Absolutely.
They could charge.
There are some charges pending. There are criminal
against
charges.
the two people who picked this runaway girl up.
But let me tell you, the statute that says when you can have your license revoked lists certain crimes that might be committed inside the establishment. Not in there is anything that happened to this girl. Now, I would argue that they can go under Texas state law, because the state law may prohibit someone who's under 18 from working in this kind of business. And if they can get them on the state,
you can still for child endangerment.
Absolutely.
Now, the child comes from a chaotic home, obviously. She's now being cared for by her grandmother. And, you know, let's face it, we know what the situation is. Troubled child, no family structure, runs away, two leeches grab her, a 27-year-old woman, a 22-year-old man. They are charged with felonies, by the way. Okay. But I think the club management should be charged with a felony here.
Absolutely, because they were conspiring along with these other two.
Child endangerment, that's something that can be brought in every municipality.
You can make a good case. I mean, I will say in the club's defense, and in the club's defense, I will say even the child's relatives say she looks a lot older.
But everybody have to be sure. And if somebody says, I don't have an ID, then get one.
I'm just saying, I totally agree with you. I'm just saying that that's the defense they're going to run into.
Now, on the same thing, in Texas, they want to, is it Dallas or Texas?
It's Texas.
All right, Texas, they want to charge $5 for everybody going into these clubs to use that money to pay for abused children. And the court struck it down, right?
Yes. Here's the problem. The reason they can't do it is because when you have a tax like that, a sin tax, as they're referred to, it can't be content-based. You can't be targeting one particular form of expression, like stripping. And when you do, when you do that, the law gets scrutinized under very strictly.
Why don't you say, look, any kind of establishment that trades in this kind of a thing has to pay the tax?
No, not this kind of a thing.
No.
If it, like in Nevada, they say any live entertainment gets taxed.
Any
okay,
live
that's fine. That's fine.
But just because you get naked, you can't be charged.
You can't do that. You can, but the law would have had to be a lot tighter than it was here.
But they can redraft that and make that much better.
They could, but what, you don't want to put other people out of business, then this would hurt them. Now, the Passengers' Bill of Rights, this is another thing.
Right.
New York says that if you abuse your passengers at a LaGuardia or Kennedy or any other New York airport, you can be fined by the state of New York because your flight originates here. And a federal judge said no.
Right. The decision stinks, the outcome stinks, but the judge is right because the Supremacy Clause of the Constitution says federal law trumps state law. The feds have already said, look, we're covering federal air regulation and services. There's already a law on the books for that. So if you want to regulate the airline industry, you have to do it through federal law. So there's got to be a federal...
Why, though? If the flight originates in New York, why can't New York authorities say...
Because federal law always trumps state law. The Supremacy Clause trumps
it. Can you explain it to me?
Yeah, the reason is because we can't have New York imposing one set of requirements, California imposing another, Illinois, which it flies over, imposing another.
New York on the ground, not in the air, is subject to New York law, no?
No, it's not, because where the feds have chosen to regulate, the states cannot regulate.
So because the FAA has overall authority on the airlines, that state of New York or any other state can't make laws inside the airport.
Nothing that's inconsistent. And the feds have already said, when it comes to services on board an airplane, we control.
That's
and New York tried to jump in, and the feds said, we control.
So the customers get hosed again.
No, the customers can do one of two things. Go to the airlines and push for a passenger bill of rights within the airline, or go to the feds and get the federal Congress to pass a law.
Well, the federal Congress should. We might leave.